Assalamu alaikum, how are you all? So, in today's discussion, I have the intention to talk about the legal matters, and every time I'm so much passionate to talk about the legal matters. So, as a part of this, my realization to talk about the legal and social matter and its impact on the socio-legal perspective. So, first of all, I would like to mention my topic. So, in today's discussion, I can discuss about the consumer protection problem in Bangladesh. First of all, have you any kind of laws related to the Consumer Protection Act? The answer is yes. We have a very good laws which was established in the year 2009. The law's name is Bangladesh Consumer Protection Act 2009. But the biggest dilemma is that 90% of our common people, 90% of our ordinary people, they have no idea about the Consumer Protection Act. So whenever you have laws, regulations, codified conduct, principle, bylaws, and precedent, but you can't apply these types of Consumer Protection Act in your own analysis or interpretation. You know that as a consumer, you have 8 fundamental rights from the government. According to Article 32 of Bangladesh Constitution, it is directly ensuring that every people has right to life and human dignity. And one of the cases of Indian judgment clarified that right to get the proper food, right to get the proper education, even right to get the safety food from the government is on kind of human safety, and it's related to the human dignity. So from this perspective, I can say that every person has legal, social, and practical right related to the consumer protection activities in Bangladesh. So basically, the question is how the Bangladeshi government, even how the stakeholders will interplay and with implement the Consumer Protection Act in Bangladesh despite lots of controversies and limitations of our Consumer Protection Act in Bangladesh. The first reason is that Consumer Protection Act is a very well known and well formed law. First of all, the government should utilize and liberalize these types of fundamental rights to the all kinds of people, as the people they are more concerned about the environmental issue as well as consumer protection activities. The second reason is that whenever people will be more educated in the sector of consumer protection, in the time 90% of the problem has already been solved, because whenever people will be cautious about the consumer protection, consumerism, consumer rights, consumer education, consumer consumption, even the consumer database, in that time all kinds of problems will be disseminated and will be solved with a very short time. The third reason is that what is the utilization and sponsorship of Consumer Protection Act in Bangladesh. Even you know that in consumer protection activities our government is very liberal, and they are making a very good choice for the people, for the ordinary people, and for making a very good context and sustainable way of getting the remedy from the court. Even most of the time the government has initiated the mobile court system in interplaying the consumer protection activities in Bangladesh. Despite lots of problems, lots of social eradication, consumer protection activities and act is on kind of basic issue for the development of the sustainable consumerism in the modern age of 2026. In that mechanism, the government can take the another advantage of the Food Safety Act, because Food Safety Act 2013, it is on kind of basic act. If any kind of person contaminated the food with colorable insects, colorable acid, he will be punished for death penalty. So you know that in Bangladesh it is said that for food contamination you can be penalized for death penalty. But who will build the cat? Who will implement these types of legal proceedings in our common legal phenomena and in our common legal system? I think that in that mechanism the government will not make a very good analysis over the issues. The NGOs, the stakeholders, even third parties, even with the students, we have to come forward to overcome from this situation and to make a very good realization interpreting the Consumer Protection Act and Food Safety Act 2013. Even the another dilemma is that our stakeholders means who are directly connect with this matter profoundly and profoundly. So I have to mention an institution whose name is Consumer CAB, Consumer Association of Bangladesh. So Consumer Association of Bangladesh is on kind of voluntary organization whether people will identify all of his problems, and these types of problems will be solved by the Consumer Association of Bangladesh. The director, the advisor, they will solve out the issue with the affiliation over the government. But I think that CAB has lots of functional problem. Even some of the times CAB directly or indirectly work on the basis of nepotism and on the basis of corruption. That actually and literally change the whole stakeholders and whole system of our consumer protection in Bangladesh. So why consumer protection activities is literally important in the perspective of Bangladesh. First of all, I should say that we have to follow the international standard, whether the international convention and conventional way has already been applied the consumer protection activities. So we have to always be cautious about the activities. As per Article 32 of Bangladesh Constitution, it is directly mentioned that every people has right to life and legal remedy. Every people has right to life and social dignity. So without the procedural advantage of the Consumer Protection Act, right to life will never be safe. Right to life will never be implemented for the perspective of Bangladeshi people and Bangladeshi institution. You know that in Indian judgment there is a very good judgment of the Chamkam Dorairajan versus state of Andhra Pradesh. So in that mechanism the petitioner filed the petition on the basis of the contamination food, and these types of contaminated food is directly or indirectly harmful for the human health and the human dignity. So the High Court division will fully demonstrated that these types of activities is totally prohibited, and the institution will never take these types of advantage